during the second day of this conference. I will moderate this panel in English because most of my participants here speak English, and I think it will be just easier for the sake of conversation and discussion with our panelists. My name is Bodnar. I work in the Helsińska Foundation for Human Rights in the Legal Division. And I have a privilege to greet and welcome three distinguished guests of this conference and experts on human rights law, humanitarian law, and international human rights law. And so I would like first to present them in alphabetical order. So first speaker will be Professor Klaus Bachmann. Professor Klaus Bachmann is a great friend of Poland, residing here for already many years, writing a lot about the process of the European integration, first as a journalist, later on as a scholar. He is currently professor at the Wrocławski University, as well as in the school of in the high school for social psychology, Szkoła Wyższa Psychologii Społecznej in Warsaw. He is also founder and head of the think tank Center for European Studies based in Wrocław. Recently, Helsinki Foundation for Human Rights had the privilege to cooperate with Professor Bachmann on the organization of a conference devoted to the war in Afghanistan. I think the conference was quite a success. At least we are quite happy with as regards cooperation on this conference. The second speaker will be Professor David Jones from Warsaw University. Professor David Jones is a professor in the chair in the American Studies Center at the Warsaw University, as well as in the International Relations Institute. He teaches on constitutional rights and freedoms, on American law. He is author of many publications, traveled a lot to many different countries and lectured in different universities, both in US and Eastern Europe, including such places like Latvia, Estonia, and Poland. Recently he worked mostly on his book on China and the approach of the Western world towards China. The title of the book most probably will be The Eagle and the Dragon. And the book will be published in 2012. And last but not least, our guest from Costa Rica, Alexandra Nuno, from the Center for International Law and Justice. Mrs. Nuno litigates cases before the Inter-American Commission of Human Rights and Inter-American Court of Human Rights. So it is the rare opportunity here in Europe to listen to somebody who believes not in Strasbourg but in some other regional system of protection of human rights. She is a graduate of the LLM program at the Essex University. She is currently the head of the division dealing with Mexico and Central American countries in the Center for International Law and Justice in Costa Rica. Last year she had an opportunity to make a speech before the Western Hemisphere subcommittee in the US Congress, speaking about the freedom of speech situation in countries of Central America, with a special emphasis on Honduras. Okay, so I think we will start, and I would like only to add one point. That idea of this panel was given by Professor Wiktor Osiatyński, who greatly contributed to this conference and this program. And this topic, the convergence between the humanitarian law and human rights law, in fact refers to the lecture which has been given by Professor Theodor Meron 3 years ago. 3 years ago, Professor Meron was one of the guests during the Marek Nowicki lectures. Professor Meron is one of those authors who and judges in the Criminal Court for former Yugoslavia who established the doctrine of convergence of the human rights law into the humanitarian law, including such notions as the definition of rape and inclusion of a rape as a war crime. So I think it is like a quite interesting connection between our previous lectures and experience here in Warsaw and today's session. I would like only to add that Professor Meron last year was also awarded doctorate honoris causa of the Warsaw University for his contribution, and I think that our lecture here in Warsaw will be bringing him closer to this doctorate honoris causa. Okay, so we will start, and I would like to give the floor to Professor Bachmann.
Yes, thank you very much. I hope you all, can you hear me?
Yes, okay. I hope you all enjoy our beautiful Polish autumn today. I think it's also the reason why I'm the first here, because it will be my task to wake you up and to bring your blood pressure to peaks. My presentation is called The Dark Side of Retributive Human Rights Protection, which is in itself quite provoking, because usually we don't think about dark sides of human rights, and probably if Theodore Meron was in the room, he would throw objects at me during this lecture. But maybe it will be a good provocation to get awake. Now, after the third wave of democratization, and until now, more than 40 countries created Truth and Reconciliation Commissions. These Truth and Reconciliation Commissions, opposite to what they claim, usually do not provide reconciliation. At least it would be empirically very difficult to prove that they do, except for some rare or, yes, not very numerous cases. They do not provide justice because they do not punish perpetrators. If perpetrators are punished, they are mostly punished by other institutions, or the Truth and Reconciliation process is connected closely to an amnesty process. But they do something else. They give victims a voice. They enhance unity. In divided societies, they create very often a new uniting narrative, and they do something which is also very important, but often forgotten, and something they do not even claim to do. They legitimize the new political order that emerges from transition and delegitimizes the old political order. And sometimes they also trigger a process of paying reparations to victims. Despite this, I would say, overwhelming tendency to create Truth and Reconciliation Commissions, until now we do not have an international Truth and Reconciliation Commission, but we have an international criminal court. Of course, creating an international truth commission would be nonsense, because we would not be able to create a narrative. It would be probably a very international or very cosmopolitan narrative it would create, and would probably not be adopted by the local communities it is dedicated to. So that does not make any sense, but nevertheless it is striking. It is striking that despite this overwhelming tendency to create truth and reconciliation processes and truth and reconciliation commissions, on the international level, we have a very strong preference for retributive justice. Just for those of you who are not lawyers and are not familiar with the division between restorative and retributive justice, that's why I put this here on my PowerPoint, so that you can see what kind of definition for both kinds of justices I'm using here. Yes, transitional justice was restorative on the local, on the national level, but it became very retributive on the international level. So we don't have an international truth commission, we have an international criminal court, we have the international criminal court for the former Yugoslavia, we have the international criminal tribunal for Rwanda, and after 2000, or beginning with 2002, we have the international criminal court in The Hague. We have a lot of hybrid tribunals, internationalized courts, special chambers, and they all do very retributive justice. They also do not provide reconciliation. It would be very, very difficult to prove that there is any impact on reconciliation from these tribunals. They provide a very narrow concept of justice, which is very much dedicated and concentrated on main perpetrators, on prominent figures, on important politicians, on what we would say in everyday language, the big fish. They do not give victims a voice. They cross-examine witnesses, but this is something very different to giving victims a voice, and many victims, or many witnesses have appeared before these courts afterwards, were very disappointed about what they were, to what aim or to what end they were used in the court, and how the whole process works. But they do something which makes the difference with the Jewish commissions. They punish perpetrators. Because they punish perpetrators because we believe that this might deter other perpetrators from committing crimes, and because we believe that it prevents current perpetrators from going on, from continuing with committing crimes. This has led the emergence of the ICC, the question of universal jurisdiction, the implementation of international criminal justice concepts in national law has created a situation which, first of all, has become very retributive, very perpetrator-oriented, and really very universal. And it is more and more, it doesn't leave any exit for transition. That's the most important point I want to make today, and I'm going to explain now what I mean by that. Today, let me start with another example. In the former times, a perpetrator, a dictator, who gets under pressure in this country from the opposition, who is threatened with transition, who is threatened with possibility of being overthrown, of leaving his power. He had different possibilities how to act. Of course, he could stay and fight. He could go away, and he could spend the rest of his life in Florida, or maybe on the Crimea, depends on which part of the Cold War divide he was before transition. He could take a lot of his wealth or his money he had taken away. He could take it with him. So he did not really lose very much. This is, of course, a situation which we all regard as rather immoral and far from just and satisfactory. But nevertheless, it was a good exit strategy for our perpetrator, for our dictator. Today, it is very, very difficult for many perpetrators and for many dictators to get away with that. It's very difficult because we have a lot of institutions that act independently from states, from the international community, and basically, at the moment when a dictator stands in front of the dilemma I try to show here on the PowerPoint, the outcome is no longer predictable. The outcome is no longer predictable because, first of all, in any situation, except for a few exceptions, in any situation, he's threatened with the situation that even if he's granted amnesty, or if he leaves the country and goes into exile, for example, he may be arrested on behalf of the ICC, on the basis of universal jurisdiction, or even on the basis that the amnesty in his own country might be put into question. What do I mean by put into question? So most of these possibilities, which are shown in this PowerPoint, are no longer available, or they are much less predictable than they were in the past. But I want to come back to the question of what does it mean to put into question national amnesty. If you look at the situation, it was very, very interesting for me to look at the situation in Spain when Baltasar Garzón tried to use international criminal law in order to undermine the Spanish amnesty for the Franco time of the Civil War. Because what does that mean? That means, and I think it's possible in other cases too, and it could have been successful, just to say that amnesties can cover usual crimes, but they cannot cover crimes where there is an international obligation to punish. This is exactly the argument Balthasar Garzón wanted to make. He wasn't successful, but nevertheless, I mean, from a legal point of view, it's very logical. But it also means that even a perpetrator who stays in his own country and gets an amnesty, he may not be able to predict the outcome of this transition process. I mean, in other words, if you look at the situation in South Africa, where we had the probably most successful Truth Commission that has ever existed in the last 30 or 40 years or so, if we look at this situation and we say, okay, if we apply the concept of Balthasar Garzón to South Africa, then the apartheid regime should never have been abdicated. Because the exit strategy that was available to them, to get amnesty through the Truth and Reconciliation Commission, if they deliver the evidence, if they tell everything they know about their crimes, then they will get amnesty. This was no longer available. It would have been today. It would not be available because, first of all, the ICC may not accept it and South Africa has ratified the ICC statute. Second, it may be put into question by South Africa itself at a later stage by bringing in the Balthasar Garzón argument that this is no longer available for crimes against humanity or genocide or grave breaches of the Geneva Convention could have been applied probably only to situations outside South Africa, but crimes against humanity or yeah, basically, that's for torture, for example. The problem is then, if we have a perpetrator who has no exit strategy anymore, then he will. Oh, that's the structure that has emerged in the last, let's say, 10 or 20 years on this level. If there is no impunity, if there is no exit strategy available anymore for a perpetrator, then we have the problem that such a perpetrator or such a dictator is forced to fight until the bitter end, which is actually what we have witnessed in Libya. Which is actually the reason why, for example, the United States, after fighting for the referral to the ICC, they very quickly became aware that they have closed an important door which could enable Gaddafi to flee abroad into exile, because this was no longer predictable. He no longer knew what would happen if he went abroad, actually, and they started to negotiate with Gaddafi about what should be done in order to protect him from the investigation from the ICC prosecutor, which is a very funny situation, because first I'm a political scientist. I very much like game theory. From a game theory point of view, it means that you first try the cost of transition, and then to try and negotiate to get it down again. I mean, this is a very funny situation, and it's probably, as far as I've heard, when I recently I was in Washington, this is one of the main reasons why, for example, the Security Council does not even attempt to defer the case of Syria to the ICC, because they know they probably might have the same dilemma after that. So, externally imposed retribution and its consequences leads to this situation where we have a transition where the perpetrator or the dictator fights to the bitter end, raising at the same time the costs for transition and causing more casualties and more victims than would reasonably be necessary. So the question is also if this kind of retributive human rights protection, which bases very much on the opinion that retribution deters from committing crimes, which in my opinion is very doubtful, very questionable, but that's the main basis. If we these, if we have this tendency towards retributive human rights protection, we also have to face the fact that this actually endangers and very much complicates transition to democracy. Which is my point, that we have to, unfortunately, it is immoral, I would say. It looks immoral and it looks very repugnant. But if we think not from, if we base our thoughts and our concepts not on what is just and fair, but on what should be a good outcome, more pragmatist view on the whole process of implementing international criminal law, then we actually should try to give dictators a chance and an exit strategy, because this facilitates democratization more than forcing them to fight to the bitter end. We should less try to deter and try to create feasible outcomes. We should less argue with morality and more with pragmatism, because it's the outcome that counts at the end. I mean, we want these countries to be democratic. We don't want them to punish perpetrator and then well, there's no one left to govern the country because all the others are dead, right? That would be a very retributive outcome, but it wouldn't make any sense. And we should think about if there is a universal duty to come to terms with the past, or if this is a local right to do it in every country on its own way. This is the point where I come back to the first presentation from yesterday morning about the question whether human rights are universal or not. And thank you very much for following me, and thank you very much for your disapproval. Thank you.
Professor Bachmann warned me that he is going to provoke us, and I hope that after 3 presentations there will be a lot of food for discussion. I have already a couple of questions to Professor Bachmann, so if the audience will not be active, I will ask you. So I also warn you. Now I would like to give a floor to Professor Jones. Professor Jones.
Thank you very much. Good morning. It's my honor to be here. My topic will follow, I think, quite neatly from Professor Bachmann's material, and you will see some potential applications of what he has said, as has been said rather provocatively. My topic is the Hague or Tripoli, the Libyan National Transitional Council, the International Criminal Court, and threshold jurisdiction to try and punish Saif al-Islam Gaddafi. He's Colonel Muammar Gaddafi's son. I'm going to refer to some documents here, but much of what I'm going to say is spoken extemporaneously. I want to give you a slight background, both of the events leading up to the current status of the ICC, the International Criminal Court, the ICC, but also about Saif al-Islam Gaddafi. Make sure we understand that Saif al-Islam Gaddafi is about 39 years old, which would mean that he was 3 or 4 years old. I'm sorry, that his father had been in power as dictator of Libya for 3 or 4 years before he was born. So that even if somehow in our imagination we wanted to hold the son accountable for the father, that would be wrong and not even logical for a good deal, well over half of Muammar Gaddafi's term in office. And that would include presumably also the allegations that Libya commissioned or sanctioned the attack on the Pan American airline that went in in Scotland in 1988, where Saif al-Islam Gaddafi would have been about 16 years old. So that the the credible and viable accusations against him stem from more recent times, largely accusations that he participated with his father in repressing demonstrators who intended to, and finally did, overthrow the Gaddafi regime. Let's back also. We realized that the ICC was not created in a vacuum. The ICC was created really in the aftermath of, in the aftermath of World War II. And one fact here that I don't think is too widely known, but is significant to what we're talking about, would be the Cairo Summit Conference between President Franklin Delano Roosevelt, British Prime Minister Sir Winston Churchill, and Chinese Kuomintang National Party Generalissimo Chiang Kai-shek, otherwise sometimes referred to as Chiang Kai-shek, where at Cairo, Jen shocked President Roosevelt and Premier Churchill when speaking through his Chinese-American wife, Zhang Sun. Zhang said that he expected that the victorious Allied powers would not indict His late Imperial Majesty Emperor Hirohito of Japan, would not prosecute him, would not remove him from office, and would not attempt to execute or imprison him. So the point is that we have a mixed bag internationally on what to do with different leaders. Not that I am trying to associate Hirohito with Gaddafi. Hirohito was a man of letters. Arguably, he was a first-rate marine biologist, yet global atrocities were committed in his name. So what I want to concentrate on today is the issue of Saif al-Islam Saif al-Islam Gaddafi. And I'm going to just read off part of my preparation. Some of the more difficult questions surrounding the International Criminal Court, better referred to as the ICC, concern its threshold jurisdiction. These questions and confusion over the answers thereto may be counted as the primary reasons why the three most powerful countries in the world, China, the Russian Federation, and the United States of America, have delayed and prevaricated in their endorsement of the ICC or joining its membership. On that score, be it remembered that the United States signed but did not ratify the Rome Statute that is foundation of the court of the ICC, and then later in the George W. Bush administration, the United States purported to unsign its agreement there. The Russian Federation has signed but not ratified, and both China and India, the two most populous nations in the world, have not signed, and in fact have critically attacked the ICC for different reasons that they have explained. Maybe or maybe not explained logically. So the question is coming to a head in the eyes of the world, and not only the legal community, whether the Libyan National Transitional Council and its sovereign successor, if any, or the ICC, should put Saif al-Islam Gaddafi on trial, and if he's convicted, punish him. In the end, may determine the future of the ICC, the future of the Libyan National Transitional Council, and the fate of the freedom movement that has come to be known as the Arab Spring. I want to focus on the current status of the situation with Saif Gaddafi, largely because the conference addresses the current stature of issues in international law, here humanitarian issues. So this is entitled "The Situation in Libya in the Case of the Prosecutor Against Saif al-Islam Gaddafi and Another Person, Abdullah al-Sanusi." I'm going to focus on Gaddafi and not Sanusi. It's before the pretrial chamber 1. It is valuable to note some of the procedural history in briefing a legal case. As you know, we tend to look at facts. The procedural history is that Resolution 1970 was adopted by the United Nations Security Council on 26 February 2011, whereby the Security Council referred the situation in Libya since 15 February 2011 to the prosecutor of the ICC and decided that the Libyan authorities, quote, shall cooperate fully with and provide any necessary assistance to the court, unquote. Of course, they were referring to the Libyan authorities under Muammar Gaddafi, but international law is quite clear that successor governments who claim to inherit the benefits of a country after transition also inherit the burdens. So presumably the Transitional Council is bound by the Security Council referral. The second part of the procedural history, on 27 June 2011, the, quote, decision on the, subquote, prosecutor's application pursuant to Article 58 as to Muammar Mohammed Abu Minya Gaddafi, Saif al-Islam Gaddafi, and Abdullah al-Sanusi, and subquote, end quote, was issued by the Chamber. We call this an arrest warrant decision, as well as warrants of arrest corresponding to that decision, derivative warrants. And the ICC Chamber decided that the registry, that's functionally the clerk of the ICC, should prepare a request for cooperation asking for Libya's assistance in arresting Saif al-Islam Gaddafi and others and surrendering him to the court. And all this was completed by delivery of the request on 4th of July 2011. The third part of the facts is through internal channels of the Office of the Prosecutor, the ICC received on 23 November 2011 by a facsimile, by a fax, may be important here, a letter that was allegedly from the National Transitional Council. The letter confirms that Saif al-Islam Gaddafi was arrested on 19 November 2011 and alleges with reference to Article 94 of the Rome Statute that the surrender request will be discussed and the court, ICC, will be officially informed when a transitional council decision is made. This is referred to as the Libya letter. Fourth aspect of the facts, the prosecutor filed the prosecutor's submissions on the prosecutor's recent trip to Libya on 25 November 2011, and the prosecutor then discussed with the Transitional Council officials the possibility of postponing the surrender of Saif Gaddafi pursuant to Article 94 of the Rome Statute. And this has a number of details with it, but is heavily dependent upon whether or not the Transitional Council arrested Gaddafi pursuant to the arrest warrant issued in The Hague by the ICC, or arrested him for some other reason. We don't know the answer to that, and one could easily remark that it would certainly improve the legitimacy to take forward a concept that Professor Bachmann had introduced today, the legitimacy of the Transitional Council if it would explain what its reasoning is, and do so very, very quickly. Fifth part of the factual situation is the Office of Public Counsel for the Defense, the OPCD of the ICC, submitted a filing in response to the prosecutor's submission on 28 November 2011, asking that the Chamber, the court, in the event that Saif al-Islam Gaddafi has not appointed counsel, to authorize the OPCD to present observations concerning the general interests of the defense in any and all proceedings, which the prosecutor opposed on the 1st of December 2011. All of this is clouded in a way, and this could be clouded beneficially, clouded detrimentally, or clouded deceptively, I would argue, because on 30 November 2011, the ICC registry confidentially filed the and observations of the registrar pursuant to a communication that it received on the 27th of November 2011 that indicated that apparently private counsel from somewhere in the world had contacted the ICC purporting to represent Saif Gaddafi and asking to be recognized as such. The ICC has blacked out information available on the identity of this counsel because, and I think quite responsibly, the ICC is concerned whether or not Saif Gaddafi consents to being represented by this counsel. You can see several combinations or permutations here that this could be some false counsel representing some other interests, or could be some a group of people trying to deprive the ICC of jurisdiction. Virtually no court is going to allow arguments to be made by parties representing parties where there's no firm guarantee that the representative is authorized by the party in interest. And one further factor, ICC denied the prosecutor's request for a status conference on the 1st of December 2011. Well, that's where I want to jump in and provide some type of analysis here. The Chamber is asking the Libyan Transitional Council on an urgent basis, because I think you can imagine and appreciate how urgent this matter is, both for the safety of Gaddafi and for the image and legitimacy of the court, the Transitional Council, etc., Security Council even, that they want answers to the following questions. Whether Saif al-Islam Gaddafi was arrested on account of the court's warrant or for some other reason, whether the information received by the ICC as to Saif al-Islam Gaddafi being held incommunicado is true. When and where could the registrar or one of her representatives meet Saif al-Islam Gaddafi in order to seek his views on being assigned counsel for the court or appointing his own counsel for purposes of proceedings before the court? And fourth and last, how and where could an expert be mandated by the court to examine Mr. Gaddafi himself to assess his physical and mental state? And fifth, whether and when Libyan authorities intend to surrender Gaddafi to the court. You can imagine the idea under international law of holding someone incommunicado is just about 180 degrees anathema to the principles of international law and the purposes of the ICC. The purposes of the ICC are to open transparently the allegations against the accused and to give the accused a full and fair opportunity to defend herself or himself against those allegations. That's being frustrating, and quite significantly so, to the extent that Gaddafi is being held incommunicado, and the representatives of the international community are not being allowed to meet with it. We don't know what this purpose is. Let me suggest some other issues here as well. One is presuming that for this purpose the Transitional Council represents Libya. But I mean, I don't know that, nor do I know that you know that this is true. In a way, we think of it as being commendable that a group of people, many representing the international community, went to battle to take back Libya. Many are of Libyan descent, and they prevailed ultimately in turning the tide in Libya. That alone does not give them necessary legitimacy to rule Libya. Libya should be ruled by the Libyan people. There needs to be an internationally supervised election, of course. But assuming without deciding right now that the Transitional Council does represent Libya, then certainly it would be in its best interest internationally if it I think if it surrendered Gaddafi to the ICC. I don't think the Transitional Council is in a position to give a full and fair trial to Gaddafi right now. If it doesn't do that, and especially if by not doing that, harm comes to Gaddafi, I think this would seriously tarnish the ability of the Transitional Council to go forward and appropriately rule Libya, if that's what it intends to do. Let me remark something that many of you may disagree with. Don't think you disagree with me that when I opposed the when I opposed the execution of Saddam Hussein in Iraq, I think most of you probably would disagree with me, well you might not, that Saddam Hussein did not have a fair trial under either British or American standards, much less international standards. I'm afraid that this is the situation that probably would happen with Saif Gaddafi if he were to be tried in Tripoli. That said, of course, we do have to respect the sovereignty of different countries. This was discussed at a panel on which I sat yesterday. One person proposed, I don't know how seriously, that sovereignty should be abolished, and I disagree with that. I think most of the international community would be reluctant to adopt that posture broadly. Libya's sovereignty is intact. The question is, who is sovereign? But there is concern in the international community for the safety of Saif Gaddafi and for proceedings that involve him to be transparent to the world and fair. Even if they're transparent, as Saddam Hussein's more or less were, if they're unfair, there's always the cloud of a whitewash if he's acquitted, the cloud of unfair retributive justice if he's convicted, and especially if he were to be convicted capitally and executed. As you realize, the international community does not have capital punishment and opposes it. So we have this issue. We have some other issues as well. One of them would be the extent to which Libya is subject to the jurisdiction of the ICC. Now, as Professor Bachmann introduced, one of the major threshold jurisdictional elements of the ICC is a reference by the Security Council, which is the case here. It would not be possible under the current Rome statute for situations arising in Libya or involving Libyan nationals to be prosecuted in the ICC otherwise, because Libya is one of a handful of countries in the world that's not a member of the ICC. For this reason, I would argue to you that I think it's difficult to be teary-eyed if Gaddafi then claims that the ICC should have acted sooner or more vigorously to secure his transfer. He went into a great deal of public discussion in the last days of his father's administration, in which he said, this is our Libya. And by our, I don't think he really meant the people of Libya. I think he meant his fathers, his families, and his Libya. So in a way, they made their bed and they lie in it. The reason for transferring him, in my judgment, is not so much to protect him, although from Hirohito down, we see that forgiveness is a part of the international mandate. But I think that the reason for transferring him is, again, the transparency, the truth, as Professor Bachmann introduced, that we want there to be closure with the victims of Gaddafi's father's horrendous crimes over 42 years. We want these victims to be able to come forward, tell the truth, and have the truth recorded transparently for the world to see. And only in doing so are we going to be able to really determine the involvement, if any, that Saif al-Islam Gaddafi may have in this sordid sequence of events. He does seem to have some facial culpability, and that facial culpability could be very, very extensive. On the other hand, it could be that it's less extensive. He claims he's innocent, and he also, people around him have raised in question the issue of his earlier cooperation. He's a mixed bag figure. He flew to England to return to Tripoli with the person whose sentence for the Lockerbie airline bombing was commuted, and yet he offered to intervene in Islamic circles to try to prevent future terrorism. Of course, if there's a conviction, after conviction, these factors do mitigate on sentencing in any Western-style judicial process, and they should in his process as well. So what I want to leave you with today is several questions that really are not answered yet, but hopefully will be answered soon. Is Saif al-Islam Gaddafi safe, and can we be assured of his continued safety? Is he going to be turned over to the ICC, which by far would be the proper path, and if so, when? Because as we say in English, justice delayed is justice denied, not only for Gaddafi, but for the world. And what is going to be the status of a trial for Gaddafi, regardless of where it would be, but presuming that it will eventually be in The Hague? Is a private counsel going to be engaged? Reportedly, the Gaddafi's looted plenty of money from Libya, right? They're going to have private counsel, or they're going to have public counsel, but one way or another, Gaddafi needs counsel. For him to continue to go on without counsel, in my judgment, hurts the Libyan Transitional Council's image tremendously, and also could easily start to tarnish the ICC, so that those who believe with China and India and possibly the United States and the Russian Federation that the ICC is not a well-constructed entity would be able to muster greater evidence in support of that argument. I think it's a very well-constructed entity. I think some improvements could be made, and I'm hoping that that result does not occur. Thank you very much.
Thank you very much. So we had one presentation dealing with, in general, with retributive and restorative justice, and one case study presenting different challenges in front of finding justice in Libya. I would just add, refer to the comment made yesterday by Anna Husarska during the lecture, after the lecture of Professor Badinter, regarding the training which was organized by the Helsińska Foundation for Human Rights in Libya, in Benghazi. So our trainers made something like an Oxford debate, and the topic during this debate was whether Muammar Gaddafi, who was still alive at the time, should be tried in front of Libyan courts or in front of ICC. And in the very beginning, nobody wanted to argue for ICC because they thought that there is no death penalty there. So we are not interested in this, but the outcome of the Oxford debate was that the majority has changed the attitude, and they thought that Libyan courts are not prepared to provide the fair trial to Muammar Gaddafi. But so the question is, what will be the outcome of the trial in case of Saif Gaddafi? What will be their approach to this issue? Okay, so I give the floor now to Alexandra, Nuno, please.
Usually I don't need a microphone because my voice, you can hear it without any microphone at all. I want to thank the organizers for on behalf of Sahib, for the invitation. And I wanted to start by saying that we all know that there are some realms in the international law that have their own specific provisions, treaties, supervising or monitoring mechanisms, such as the international refugee law, international humanitarian law, and of course international human rights law. No? But I think that the question raises when there is a huge problem with so big humanitarian implications, what should we do, and whether these laws can have convergence in the protection of justice and of course of thousands and thousands of victims that suffer really gross human rights violations, no? So I want to take you, you have heard a lot of Europe, and you're in Europe, so I want to take you to a more tropical region, which is the Americas, and specifically Latin America, no? As you may be aware, in the 1970s and 80s, in some cases before and in some cases of course after, Latin America really suffered from gross human rights violations, either by authoritarian regimes. In Mexico we had 70 years with the same political party until 2000 when President Fox came in power, but we also had several coup d'etats, no? Ecuador is one of the main and the leader in the coup d'etats. In 2010 there was another not successful coup d'etat against President Correa, but we could all see it with a lot of fear, because it meant that maybe we didn't learn from other experiences, and we again started both in Ecuador, in Honduras, and in Venezuela with the same nightmares that we had lived in decades before, no? But in Bolivia we have coup d'etats, in Chile, Uruguay, Argentina, Paraguay. Those are some examples, because I can go on with some other cases. And in those cases, in many ways, they then became, of course, military or dictatorships after the coup d'etats, no? But not only we have coup d'etats, but we also have dictatorships, no? We are very creative in Latin America, and we don't need sometimes only coup d'etats to have really dictatorships. In Brazil, for example, with Castelo Branco since the 1960s till 1985, in Honduras with a military junta, in Panama with Noriega, in the Dominican Republic with Balaguer, in Bolivia with Banzer, in Nicaragua since the 1950s till the 1979 with Anastasio Somoza, in Peru, and so on, no? And specifically, well, Peru has their own specific characteristics, because it had dictatorships, but then also it had an internal conflict, no? Since 1980. But maybe the three most impressive armed conflicts in our region was, of course, Guatemala, with more than 200,000 civilian victims, no? From them, 45,000 disappeared, and 5,000 disappeared children, no? El Salvador, with 12 years officially of armed conflicts, as the Truth Commission said, and the peace accords as well, had 75,000 civilian population victims, no? More than 7,000 disappears, and many displaced displaced persons. And in Colombia as well, as you may be aware, after 1948 with the killing of Gaitán, there started an armed conflict which is the most long and prolonged within our region, leaving thousands of gross human rights violations, but maybe one of the most terrific problem is the displaced, the internally forced displacement in Colombia, which is involves more than almost 4 million people, displaced persons in Colombia. Those are official figures by the government, but many NGOs say that the number goes higher. No? Those are the facts, those are the realities that we have to live in Latin America. And what happened was that I'll try to put some bright side to the international human rights law instead of the dark side of the retributive justice. What happened is that in many of these countries, people and victims didn't have any chance to get justice done. No, that was the idea, because not only there were dictatorships, but the judiciary just didn't function at all. So that is one of the main, the golden rule to go to an international human rights organ, specifically in the Inter-American system, is that you exhaust internal remedies. No? In these cases, of course, there was no chance to exhaust those remedies. So many of those cases and those realities started becoming and getting to the Inter-American system. As you know, we still have an Inter-American Commission on Human Rights, which is based in Washington. Since it was created in 1959, and we have an Inter-American Court on Human Rights, which is based in Costa Rica, and it started, it was established in 1978-79, even though it started doing its job in the 80s and 90s. So what are the precedents within the Inter-American system regarding human rights and international humanitarian laws? First of all, I'm a lawyer and I will include some legal aspects, of course. The Inter-American system has developed what general states' obligations are regarding humanitarian problems within the Inter-Americas and in specific countries. Also, the Inter-American system has given core content to several human rights included in the American Convention on Human Rights and other human rights treaties. In the Inter-American system, we have an American Convention with 2 protocols, one abolishing death penalty, the other one regarding economic, social, and cultural rights. But we also have conventions regarding torture, the abolition and prevention of torture. We have one convention specifically against regarding violence against women, and we have another one regarding enforced disappearance and other conventions as well. But also, the Inter-American system, as you may have read, is really it has a long tradition of granting interesting, creative reparations. Reparations that really tend to either compensate, either satisfy, either establish guarantees that maybe and hopefully those will prevent that those facts and those things happen in the future. No? So I'll just give you some examples. In 1997, the Inter-American Commission on Human Rights had to decide on 3 cases. 3 cases regarding 3 different countries, no? Colombia, Peru, and Argentina. And in all of those 3 cases, the Commission had to deal with killings, no, extrajudicial executions done either in clashes or in places where there were some confrontations between the guerrillas or the military, no? And the first one regarding Colombia, it was regarding the alleged members of a guerrilla, M19. While they were already surrendered, some of them were wounded. All the state agents, the military and the police, killed them in cold blood, no? The other one regarding one journalist and his colleague that were killed, that were surrendered. They were journalists, even though they were detained and killed in cold blood again. And in the Abela case, where more than 40 persons were dead, shot dead, after, well, some of them were tortured, some of them were disappeared, and then many of them were killed after they tried to take one infantry regiment in Buenos Aires, in the Buenos Aires province. In all of those three cases, the Inter-American Commission started saying that it was the Commission was not only competent and had jurisdiction to apply the American Convention on Human Rights, but also it says that because of the circumstances of those three cases, it was competent and had jurisdiction to apply some of the rules of the international humanitarian law. So the Commission took into account Common Article 3 of the 4 Geneva Conventions, which, as you know, gives minimum provisions to states that are bound to apply just to respect life, to not torture, to give humane treatment, and so on. No? So the Commission went really further and said, okay, since Article 1.1 of the American Convention says that states have the general obligation to respect and guarantee rights, those general obligations have to be seen in the circumstances of these cases. And the circumstances of these cases were that they were in some internal conflicts. So the Commission took into account Common Article 3 to give content to Article 1.1 of the American Convention on Human Rights. And in some cases, in some way, the Commission said, I have jurisdiction to apply directly Common Article 3 of the Geneva Convention, which was a little bit further in the Commission's work. So that was the first precedent within the Inter-American Commission on Human Rights. In those years, it was very difficult to have the cases sent to the court. No? In those years, it was very usual that the Commission would just do the report on the merits and then publish the report rather than send it to the court. In 2000 and 2001, there were both the Commission and the Court's rules of procedure were modified, were reformed, and so the Commission started sending some cases before the Inter-American Court. So the Court would, in fact, have to deal with other new and different cases regarding the humanitarian law. No? So what happened with the Court? The first case that was submitted to the court was, again, one case against Colombia, Las Palmeras, which was extrajudicial killing of some alleged guerrilla members in Colombia by the military in the Putumayo department. And in those cases, the Colombian state had said that both the Commission and the Court didn't have jurisdiction to apply the Geneva Convention, the Common Article of the Geneva Conventions. No, as you may be aware, the Commission prepared the report on the merits. And in that report on the merits, the Commission said, I am competent and I have jurisdiction to apply the Geneva Conventions, but then the Commission sent the case before the court. So the state was actually confronting what the Commission findings in the merits, not in the merits report. So the court said that in that case, the court was the court agreed with the Colombian government. No, the court said that yes, even though there is a very important provision within the American Convention, which is Article 29, regarding the norms of interpretation of the Convention, the court said that neither the court or the Commission have the razione materia competence or jurisdiction to apply directly the Geneva Conventions. No? Even though the court said that in the reparations judgment, the court ordered the state to proceed with internal investigations to find those responsible for the killings, to take all necessary steps to identify one of the guerrilla or the alleged guerrilla person that was shot dead and that wasn't identified till then. They had to publish the judgment in an official gazette and in a press release of the National Police and Armed Forces in Colombia. And they had to return the remains of another alleged guerrilla member to their next of kin, as well as pay compensation to the next of kin. No? That was the first attempt to the court. No? So the court, I think, that was sort of frightened with the position of the Commission, the very progressive position of the Commission, and so the court just wanted to shut the door regarding the competence of in interpreting and applying other international treaties. But it must be said that before this case, the court had already interpreted and applied extensively, for example, the International Convention regarding the rights of a child in a very well-known case against Guatemala, Villagran Morales, regarding the extrajudicial killing of 5 boys, street boys in the streets of Guatemala. No? So the court's focus in this case specifically was different from the practice that has done before with other international treaties. But after Las Palmeras, the court's jurisprudence started to evolve. And so in very recent years after Las Palmeras, the court heard one case regarding the forced disappearance of a guerrilla leader in Guatemala in 1992, the Bamaca case, Efraín Bamaca Velázquez, and also 4 years later, the court had to deal with another case regarding, and the first case regarding El Salvador, that involved 2 disappeared children, sisters, in El Salvador in 1982. In that case, it must be said that the court, I think, was convinced that the state had to do something regarding forced disappearance of children in El Salvador, because almost 900 children were registered as disappeared children in that country. And contrary to what happens in Guatemala, for example, with disappeared children that usually they're dead, in El Salvador they were found alive in other countries. No? So international adoptions were something that the state tolerated, and so the state didn't take into account, and they didn't take any steps and measures to reunite children with their families in these internal conflicts. So in this case, in Bamaca-Velázquez, the court started saying that there is a similarity between the content of Article 3 Common of the 4 Geneva Conventions and the provisions of the American Convention, as well as other instruments, specifically regarding non-derogable rights. No? Article 27 of the American Convention, and I think that the European Convention has a similar clause, enunciates some rights that cannot be derogated in any time, no? And one of those rights is, of course, right to life and right to not be submitted to torture. Efraín Bamaca-Velázquez was captured alive. He was sent to different military places. He was tortured, and the physicians tried to see that he will be alive, so he could be tortured again and again and again. So the commission and the court said that that was against the American Convention, taking into account of, or in light of the Geneva Conventions. No. Later on, the court feels more comfortable in interpreting the convention with other provisions regarding humanitarian law. So, Protocol 2 specifically regarding displaced persons, the Commission has said that has found the state responsible regarding massacres in Mapiripan and in Tuango, and specifically has said that there is aggravated state responsibility in those cases because the state not only respected the American Convention but also the Protocol 2 of the Geneva Conventions. Also, the court has ruled against Guatemala, and in another very recent case in the Contreras siblings, specifically saying that there is a state obligation of reuniting children with their families, and if the states do not that, they're responsible for violating the rights of a child, which is protected by Article 19 of the American Convention, and also the rights of the family, which is in Article 17 of that convention. The court has also ruled on urgent measures. We call them, well, in the American Convention, is established as provisional measures. When there are communities or persons at risk, the court has issued really interesting provisional measures to protect the whole community. No? Usually the court needs to identify all the individuals that the state has to protect, but in these cases, because of the circumstances, the court ruled that the state had the obligation to protect the whole community and see that IDPs, internally displaced persons or forced displaced persons, have to return to their homes because they had been flying from their land because of the violence of both paramilitary and the militia. And it did the same with Afro-descendant communities in the communities of Higuamiandó y Turbarandó in 2003, again in Colombia. I want to end up just saying, just listing some of the reparations ordered. No, the examples, not in the theoretical point of view, but the examples of what the court has ruled. Because when it finds the state responsible, there has to be an obligation to try at least to repair those gross human rights violations. And for example, it is very usual that the court asks and orders complete, full, and impartial obligations to identify victims that are killed, to exhume some corpses and deliver the remains to their next of kin, to look for disappeared victims and restitute their identities, to make law reforms. In the Bamaca case, the court found that the international human rights the international humanitarian law was in Guatemala was not well included in their legislation, and to remove all legal and these legal or de facto obstacles that permit impunity. And in those cases, for example, the court has said that amnesty laws definitely are an obstacle for perceiving justice. They have to publicate the court's rulings, they have to train state officials specifically on human rights and international human rights and international humanitarian law. That's the order of the court. They have to take measures to guarantee that those internally displaced persons can return safely to their homes. They have to, and if they cannot go to their homes, the state has the obligation to have housing programs for them, because they are flanked because of the violence that is tolerated or that cannot be prevented by the state. They have to be public acts of apologies for the victims and their relatives. They have to give medical and psychological treatment, build monuments in the remembrance of victims. Not everything, as you may see in the inter-American system, is money. They have to act web pages of finding disappeared children, designating school with the victim names, make documentaries, have free and access to military and other relevant records, and pay damages. So I like to end by saying that it is definitely a challenge for the inter-American human rights system to try to get at the widest protection for those who suffer in our countries. And I think that these are some examples, but in many other cases, I think that we have to keep on asking the Inter-American Commission and the court to be at the level of the circumstances in many or Latin American countries. Thank you.
Thank you very much for a very interesting presentation. And just to be on this last slide, I think it is one of the major differences between the Strasbourg system and the American system. Because in Strasbourg, of course, you can obtain money, and sometimes, in some specific cases, the court gives a specific order of reparation. But usually they are not that specific. I wouldn't imagine a judgment of the court if they would say that enforcement of a judgment should result in building monuments. Such things would not happen. So the system works a little bit differently. So maybe it's something what Europe should import from Americas. Okay, I would like now to give the floor to audience. And before I start, I would especially warmly I would like to welcome Dr. Człowieka, who is the best Polish expert on humanitarian law and also the vice dean of the law faculty. Every year she organizes a summer school on humanitarian law, and she also works for the Polish Red Cross as a vice president currently. So I hope for contribution also to discussion, of course. Okay, so the floor is yours. Please ask questions, make comments, you know. Professor Nuno.
Thank you. Is this on?
Yes, it is.
It's on. Okay, I can speak quite loud anyway. Is it possible to put back up Professor Bachmann's last slide? It's easy to do, but I'd like to make a comment on it. If it's difficult, it doesn't matter.
This one.
Yeah, thank you. I thought you made a number of very good points in your presentation, so I agree with quite a lot of what you said, but I think the conclusions on the last slide don't entirely follow from your own argument. First of all, I would like to suggest to add two propositions to your four. First is be careful not to generalize too quickly from a limited number of cases. You talked a lot about Libya and South Africa, and your arguments about those cases might be valid. And the second is that any solution to problems of transitional justice are likely to be imperfect. They're going to have advantages and disadvantages. To support my first point, the two most famous cases of retributive justice, of course, the Nuremberg and Tokyo trials after the Second World War, which turned out to be quite consistent with democratization. In fact, my own view is that democratization, or at least the Federal Republic of Germany and Japan, are two of the great success stories in the second half of the 20th century. So retributive justice can sometimes be combined with democratization. On the question of giving dictators a chance, some of us believe that dictators are given far too many chances in the international system. We pay them handsomely if they have oil, like Gaddafi. So I take your point, I think it's a very important point, that when you're making the transition from dictatorship to a democracy, having an exit strategy may be very important. The example which is problematic for the ICC, in my opinion, is Uganda, where the leaders of the Lord's Resistance Army have been indicted by the ICC, and that has postponed peace negotiations between the government and the rebels. And the ordinary people of Uganda are probably suffering from that decision by the ICC. I think that's a very difficult case. My most difficult point is actually with your terminology, but it's quite important. I do disagree with less morality, more pragmatism. It's the outcomes that count. Outcomes must be judged morally. I would like you to reword that as less rigid legalism, more political judgment. I think it obviously would be quite wrong if international legal institutions had disrupted the transition process in South Africa. That required a lot of political wisdom and careful bargaining between the parties there. And international intervention would probably have been detrimental. So I don't like this less morality. It's the wrong kind of morality I think you're really against. I think the solutions you want are ones that could be morally defended, but to be morally defended, they have to be informed by political judgment. And that is likely to be different in different situations. Can I finish with the example to support my point about unsatisfactory solutions in Cambodia? There's a very complex situation because you have a post-Khmer Rouge government that happens to include a number of ex-Khmer Rouge commanders. So it's a very complex situation, and it's very unsatisfactory what has happened there. But there are Cambodians, from the reports I have seen, who were asked, do you think that what has happened in Cambodia is too little, too late? And have answered, I think, rather wisely, too little, too late is better than nothing at all. Thank you.
Thank you very much. Okay. Could you please introduce yourself? It's here. Because I think the audience does not know everybody.
Bert Lockwood from the University of Cincinnati, and the editor of the Human Rights Court, which I will be referring to. I just wanted to bring the panel's attention to some recent literature that I think is relevant. One is specifically on the topic of the panel, the sort of convergence of human rights and humanitarian law, is a recent book by Rudy Heitel, Oxford University Press. I believe it's Laws Humanity, but I'm not positive of the title. But it's very good. The latest issue of the Human Rights Quarterly has one article on reparations jurisprudence, sort of the gendering, looking at the Cotton Fields case of the Inter-American Court. And then it has a 105-page article that looks at the coalition that brought into being the International Criminal Court. And that leads me to my question for Professor Bachmann. This court, the ICC, was really brought into existence by 1,000 group NGOs coming together, a coalition of NGO groups, in sort of a remarkable example of human rights advocacy, and very excited about the accomplishment that they achieved. And I guess my question, sort of from your presentation, do you sort of think that they were naive.
Okay, I think that we will stop right now. And maybe I will add one short question to this strategy of exit, because maybe I didn't understand fully everything. Don't you see a threat that if those dictators would be allowed to escape the country and live somewhere in some nice place, they will have some incentive to come back at a certain point, or there will be some elites within the country that would dream of them coming back to country once again? Isn't that a threat for the democratic process? To you, so just no, I think that we'll just.
Okay, you want me to answer? Okay.
Yes.
Yeah, that's an interesting point. But the point is, I mean, I'm trying to make a division or a difference between retributive and restorative justice, which, of course, in this severity does not exist in reality, but it's a theoretical division. And if we accept this theoretical division, then the question is, which kind of justice would prevent a dictator better from coming back? Retributive or restorative? Well, if we look at the dictator himself, I mean, as a person, right, then of course, by bringing him to an international court and imprisoning him for a lifetime, for example, surely prevents him from going back. I mean, there is no doubt about that. If international courts would apply death penalty, it would even be more secure, I would say, but they don't. Okay. If we look at the dictators as the representation of a system, of institutions, of a social movement, of supporters, and so on, then I think the picture is much more difficult, because first of all,
they are in the international conflict. It also applies to such spheres, and for example, the transfer of persons who are detained by those military powers making intervention in a country. So for example, I think one of the, I can imagine a case in which, let's say, Polish troops in Afghanistan capture some detainee one day, and they transfer this detainee to Afghan forces without guaranteeing or without taking care about diplomatic assurances what will happen to this person from the point of view of the right to life, potential death penalty, and some other consequences. So such cases, even with respect to Poland, will start to appear, and Poland will face the reality of amending our regulations or increasing standards of our standards, taking into account not only humanitarian law but also typical human rights standards. Okay. And I think the rest of questions were just open to the whole panel. Yeah. Yes, for sure. You have to comment on this.
No, you're right. In La Tablada, yeah, it was a 30-hour conflict. And even though that the commission defined that because of the circumstances, it could be seen and defined as an armed conflict. I think that the Inter-American system has always looked through the European jurisprudence in many ways, no? And hopefully the European jurisprudence and court will look to the Inter-American system. I remember in the 1990s with the forced disappearance cases here, no? In court versus the Turkish cases, where the court, the European court, didn't find any human rights violation because they said that where is the victim, where is the disappeared victim? I mean, we cannot prove that there were human rights violations committed against a disappeared person, which is not, well, that's the idea of the state, to erase all the evidence regarding, for example, disappeared, no? So, but even, I mean, the court has been developing regarding forced disappearances, and I think that hopefully they can listen to the victims. I think that's one of the great things that we have in the inter-American system, and we've been fighting a lot so that the court still hears the victims, because in many ways, and I agree with Professor Klaus Bachmann regarding that, the idea that the court has to know what's going on in the country, in the context, so that the reparations afforded hopefully are not only for the victims and their families, but they transform realities. No, they transform realities, and they're not. They will not be seen as an intrusion by those that really suffering in those countries. No. So in the inter-American system, even though that we have very few case law, I mean, compared to Europe, we fought a lot, because in like 4 or 5 years ago, the court started saying, well, maybe I don't need to have hearings anymore. But in some cases, no? In some cases that are not as interesting as others, maybe I don't need to have, because I am becoming I am getting more and more cases through the commission. So maybe I'll stop here some hearings. And thanks, it was all the NGOs that litigate before the court, especially Sahil, we fought a lot so that we still have, the victims still have a voice before the court, because in many ways and in many countries, they don't even, it's the first time that they have the opportunity to address to an independent tribunal, no? So hopefully that we still have that opportunity, and also it's not only the litigation, but also how do you guarantee an adequate compliance of those judgments, no? That's another thing that we have to take into account, because there are many structural, but in many ways, if the state complies with it, it's impressive. In the Bachmann case, for example, if justice was to be served, the actual president, the very elected president, Toto Pérez Molina, would not be in his post, because he is one of the intellectual authors of the disappearance of Efraín Bamaca, no? So justice, in many ways, in the Americas, is really important, so that you will not only have those cases repeated, but you will not have in power those persons that were responsible for really, really gross human rights violations.
Thank you very much. Professor Bachmann?
Yes, I think I still owe an answer to the question of my second cousin about whether I think that the coalition for the ICC that, well, to a certain extent created the ICC or support, at least very much supported the foundation of it, whether they were naive. Well, first of all, I don't think they were naive. They had their own agenda. I mean, human rights organizations and NGOs. I'm working for my own NGO. They have their own agenda. What is amazing for me is how much repressive or punitive or pro-retributive, I don't know how to say that. I mean, in social sciences we would say usually repressive, because favoring repression over prevention or so. How much repressive the international human rights NGO community has become, at least when it comes to the big organizations, transnational organizations like Human Rights Watch, to a lesser extent I think Amnesty International, because they probably see also this dark side in their everyday work. But Human Rights Watch, for example, many of the members of the coalition for the ICC, the International Crisis Group, I'm currently writing a book about how external influences shape the decision-making in international criminal courts. And I had to to go very deeply into the material from the NGOs who try to influence court decisions in the last 10 years. And it's absolutely amazing that whatever happens on the political arena, on the political stage of a conflict, during the last 10-15 years, these NGOs and these organizations, they always will favor retribution no matter what the outcome is. When we have Dayton, when we have a situation like, what was it recently? Kosovo, no. Anyway, I have a lot of examples for that. And then they issue these reports, and you see also Rambouillet should not provide any, should not include any provisions for impunity. Perpetrators must be punished. And I think in every stage of the conflict, you have these things, no matter what happens. And at the same time, diplomats are trying to get the two sides or the different sides of the conflict to the negotiation table, and at the same time, Human Rights Watch would threaten them with litigation in case they do, right? So I must admit I have a problem with that. The second problem is more empirical. I remember the coalition for the ICC, and I remember the creation of the ICC. I was a reporter there in The Hague, and was talking a lot with these people. And I was to a huge extent, I was a supporter of the ICC. I find it very ugly what the Americans, what the United States did at that time. But the whole press was. We are also influenced by fashions and external influences as reporters. And I remember the main argument from the Colombian spokesperson to the ICC when I asked her why so many and I'm sorry for the terminology, but that was the way we were talking about it. Why so many weak states from third world countries ratified the ICC statute? Why would their governments risk to be taken accountable by the ICC in case they had to fight some kind of armed opposition, guerrilla or something like that? And her answer was, and of course it was an answer that came from Colombia, so I mean she was really competent for answering that. She said, look, we have a government now in office in Colombia, but they do not know what happens when they lose the election or when they lose power for some other reasons. And for them, the ICC may be some kind of external guarantee that cannot be influenced by the next government, that transition will not be too cruel. I'm putting it very, very moderate terms. I mean, but that's the thing which very much convinced me. It's a kind of, in Europe we would say, supranational authority that guarantees a transaction between government and opposition, and by playing this role as a kind of external warrant or so, civilizes or moderates the conflict. Now the problem is, if this was the reason why all these countries ratified the ICC statute, so what's the outcome? I come back to the good intentions and the bad outcomes. The outcome is that actually the ICC does not have a single case in Latin America. The ICC has all its cases in Africa. Two of them are deferrals from the Security Council, and except for one case, all the other cases were referred from governments with very, very bad human rights records against armed opposition in their own country with also very bad records of human rights. So, I mean, what is, if we compare the outcome to the concept at the beginning, and we see that both basically, I mean, it's quite the opposite, right? It's quite the opposite. The only case, I don't want to be too negative, but the only case, I have the impression that it really works in the way the lady from Colombia told me then. It seems to be Kenya. It seems to be Kenya, but actually that's a function where the ICC does not really act as a court, but as a political institution, as a kind of supranational guarantee for facilitating transition. Because what happened in Kenya is basically that the ICC says, okay, you reach an understanding, you keep that understanding. If you don't, we step in and we will punish you. The problem is that this is not the role we usually would describe to a court. He's not doing justice, he's doing politics. And that brings me back to my first discussion, which I very much liked your comments, because it means that to a large extent transitional justice is political justice, and the problem is that international criminal tribunals do not admit that. They do not say we are doing political justice. They do everything to keep politics out of the courtroom. They can't. They fail. They always did. But the problem is that I think we can solve some of these problems if we admit transitional justice is political, so we have to look at the political outcomes. Thank you very much, and sorry for talking so much.
Thank you very much. And now, Professor Jones,
I'll be very brief because I know it's lunchtime. I have several different points to make. Number one, it is political justice, of course, and the ICC is political, but I think that all courts everywhere, one way or another, are political. I've often said to my classes that, in my opinion, the least political courts anywhere are in the United Kingdom. The rest of the English-speaking world, including the United States especially, they're very political. That's one point. The second point is on the NGOs. Well, yeah, I mean, sure. When you start to have private organizations or quasi-public organizations then create public institutions, you do have an issue that's different from when you have elected legislators creating those. I don't know that by itself bothers me. What bothers me are the reasons that I think were the main ones why the United States and some other major countries have been recalcitrant to buy into the ICC. That is, it does not really have an appeal mechanism. That bothers me. I don't really subscribe to the idea that you have one chance at justice and one chance only. That doesn't mean that justice should roll on and on and on forever. It does mean that you need a higher body. Whether a bifurcated ICC in some way, I haven't decided. The second issue is that, and I think that in my presentation I didn't really go far enough, let me just clarify that. I think that you do have a certain amount of hypocrisy with the ICC, that the Security Council refers an African state, in my case I was talking about Libya, but other African states, lesser developed countries, to the ICC, but won't allow their own principles to come before the ICC. I wouldn't either. If I were sovereign of any of these P5 powers, I wouldn't allow my military officers, my civilians supervising military officers, to be subject to the ICC either. However, that said, until we bring about an ICC or something like it that encompasses both the big and the small powers, I don't think it's very workable, and I think it's obviously the image is that the ICC is political and against. It's a question, as Professor Bachmann kind of put it, it's a question of the rat calling the mouse dark, really. That many of the factions that refer the cases to the ICC, in respect, should be referred there themselves, and they don't have the power, sure. I could go on forever. I don't want to do that to detain you. It is a political process. Justice is a political process. We have to minimize the interference of politics in there. With some exceptions, I don't think we do a very good job of that globally, so I'm not surprised that the arguments are there that we don't do a very good job of that in the United States.
Ladies and gentlemen, dear panelists, I would like to thank you very much for having this panel and for